This video is for March 4th. Welcome to YesToHellWith.com. Today we continue the video series that quite unfortunately but appropriately focuses on the submission of the American people generally to the current legal system and why the Liberty Dialogues are vital to greater understanding. We will begin with an example that is a very simple way to illustrate the Liberty Dialogues, and that is with a traffic ticket. Suppose you are driving in your hometown. You get pulled over. You receive a citation. Now let's look carefully at what happens next. The officer presumes you are a statutory person under the transportation code. The court presumes jurisdiction over you. The code is applied with the same presumption as to your conduct. You appear, you plead. The process moves forward. Everything operates automatically. Now here is the critical distinction. No one first establishes what type of jurisdiction is being exercised. Is it territorial, subject matter, personal? What status is being applied to you? Private individual, commercial operator? What authority is being invoked and over what capacity? The Liberty Dialogues framework teaches something different. It does not begin with defiance. It does not begin with emotional reaction. It begins with structured inquiry. Before arguing facts, before pleading, before defending, ask, what is the legal basis? What is jurisdiction? Where is jurisdiction established? Where is applicability defined? Because courts move by presumption unless presumption is first examined. Most people argue their driving speed. In a traffic case, most defendants focus only on the factual allegation. How fast was I going? They argue. The radar was wrong. The officer misread it. I was keeping up with traffic. I wasn't going that fast. In other words, they accept the structure of the proceeding and only dispute the measurement. They argue within the system's presumption. They do not question whether the court has jurisdiction, whether the statute applies to their specific status, whether the code governs the activity as engaged, whether the enforcement authority has been properly established. Most people argue the fact pattern, not the authority structure. They defend themselves on the allegation, but they do not examine the legal foundation under which the allegation is being made. Now, look at this important boundary. This does not mean jurisdiction is absent. It does not mean statutes do not apply. It means most people never analyze those questions at all in order to determine their existence and veracity or not. They move immediately to defending the accusation. The Liberty Dialogues framework shifts attention from was I going 62 and a 55 to what authority is being exercised and over whom. Whether that inquiry succeeds in a given case is a separate matter. The Liberty Dialogues examines authority. That's the contrast. Most people live inside a legal system they do not understand. They sign documents they have not read. They accept statuses they cannot define. They comply with processes they cannot explain. Not because they are weak, not because they are incapable, but because no one ever taught them how authority actually operates. The SOU4U package is not a protest tool. It is not a loophole kit. It is not a magic language. It is a structured education in status, jurisdiction, presumption, standing, and obligation. It teaches you how to read before you react, how to analyze before you argue, how to understand what is being applied to you and why. You cannot intelligently consent to what you do not comprehend, and you cannot challenge what you cannot define. Most people live in emotional reaction to the system. The SOU4U package gives you intellectual positioning inside the system. That's what the Liberty Dialogues does. It forces clarity. It forces precision. It forces you to confront definitions. And as always, may truth reign supreme.